Hello again, I'm attorney Robert Flessas for Robbins & Lloyd Career Training Institute. This video is part 2 of course 5 regarding Wisconsin legislative updates that affect real estate practice. Let's get started. Wisconsin Statute 452.38 sets forth a safe harbor law for individuals or businesses in any field. As you know, agents associated with a firm operate independently either as a sole proprietorship or as a legal entity like an LLC. This statute creates a safe harbor for agents and firms. Most agents operate as independent contractors while working under the banner of a firm. There are 3 sources that determine if you're an independent contractor or an employee. One is the common law test that uses 20 factors. The second factor is the federal tax laws, and the third is Wisconsin Statute 452.38. Let's discuss the common law test. Common law is established through court decisions and interpretations over the course of time in this country. Here are the 20 factors. Some do not apply to real estate. Behavioral control, the extent to which the employer has the right to direct and control the work of the individual. This includes instructions given, training provided, and the degree of supervision. If you're an independent contractor in real estate, you're in control of the work that you do. You find listings, have open houses, draft and submit offers. You schedule your activities each day on your own. You're not directed by an employer. The next one is financial control. An independent contractor has the opportunity to make a profit or loss based on their own managerial skills and financial investments rather than receiving a fixed wage or salary from an employer. Next, the type of relationship. The nature of the relationship between the worker and the employer, such as the presence of a written contract, provision of benefits, and the intention of the parties involved. Investment. Whether the worker has made significant investments in tools, equipment, or facilities to perform the job. Opportunity for profit or loss. The level of financial risk the worker bears based on their performance and decisions. Services offered to the market. Whether the worker provides similar services to other companies or clients. Integration. The extent to which the worker's services are integrated into the employer's business operations. Right to terminate. The right of the employer or worker to terminate the relationship at any time without incurring legal liabilities. Regular business. Whether the work performed by the worker is a regular and essential part of the employer's business. Exclusive or concurrent work, whether the worker is exclusively engaged with one employer or is allowed to work with multiple clients simultaneously. Method of payment, how the worker is compensated, for example, by the hour, by the job, on commission. Availability of benefits, whether the worker is eligible for benefits typically provided to employees such as insurance, retirement plans, on and on. Control over work hours, the level of control the worker has over setting their own work hours. Control over work location, whether the worker can choose where the work is performed. Order of work, whether the employer dictates the sequence or order in which the worker completes their tasks. Payment for business expenses, who's responsible for covering business-related expenses, the employer or the worker. Right to hire assistance, whether the worker has the right to hire and pay assistants to help with the work. Furnishing of tools and equipment, whether the worker or the employer provides the necessary tools and equipment. Realization of loss, whether the worker would be at risk of financial loss if the work is not completed satisfactorily. The risk of business expenses, whether the worker bears the responsibility for business expenses beyond the agreed upon compensation. You'll be recognized as an independent contractor if you meet the common law requirements that I just spoke of. Well, what about the IRS when it comes to independent contractor status? Well, the IRS assumes that you're an employee unless an employer provides otherwise. Independent contractors don't have taxes withheld from their commission checks. In IRS Section 530, the IRS has a safe harbor provision to avoid classifying workers as employees and paying taxes. The safe harbor provision allows protection from IRS tax liability if a person or business shows a good faith effort to comply with the law. Basically, the IRS Section 530 safe harbor provision says that a business may not be liable for employment taxes if the business can show it had a reasonable basis for treating workers as independent contractors. If so, then the business avoids taxes, fines, and penalties by getting those liabilities waived. The IRS requires 3 elements to be present in order to qualify for their safe harbor provision. Number 1, your business must have a reasonable basis for not treating workers as employees that can be established by case law or an administrative ruling by the IRS. If the IRS performs an audit on your business by examining employment taxes at the same time you treated similar workers as independent contractors and didn't result in the IRS reclassifying your independent contractors as employees. You can show that the industry that you operate in treats similar workers and independent contractors or reliance on advice of your attorney or accountant. The second IRS element of their safe harbor provision is substantive consistency. You and your employees treat the workers and any similar workers as only independent contractors. If you treat similar workers as employees, then you don't qualify for the IRS safe harbor provision. And the third element is reporting consistency. Your business must have at all times filed all federal tax returns consistent with your treatment of the workers as independent contractors and not employees. This means that at the end of the year, you hand out a Form 1099 statement to an independent contractor instead of a W-2 for employees. What protection does the Wisconsin Safe Harbor law offer? Our law provides for independent contractor status along with compliance with the IRS safe harbor rules if a written agreement has been entered into between the firm and agent and 75% or more of the compensation that the independent contractor received from the firm during a calendar year is directly related to brokerage services performed by their agent. If you meet these 2 Wisconsin prongs in the test, then you're an independent contractor. If you don't have a written agreement that states that you're not going to be treated as an employee for federal or state tax purposes, and most of the compensation that you receive will be in the form of a straight commission. If there's no written agreement, then the firm will have to comply with the common law test that we discussed earlier. Now, many of you work as a team in your real estate independent contractor business with other agents. Members of your team then are required to meet the Wisconsin Safe Harbor requirements to maintain independent contractor status. Whether you work for a firm as an independent contractor or members of your team work as independent contractors, you can't control the independent contractor as you would an employee. But here's a twist that seems to be contrary to the determination of independent contractor status. There's Wisconsin statutory supervision law in Wisconsin Statute 452.132 that requires supervision of agents. They have written procedural rules that agents must comply with and determination that the licensee completed their continuing education requirements. I don't think that this conflicts with Wisconsin's safe harbor rule because firms must comply with the applicable real estate statutes when it comes to their independent contractors. So you have independent contractor rules that must be followed that could bump heads with the real estate supervisory rules under our statutes. As an independent contractor, you're earning your commission from your firm. You keep good records of your expenses to operate your business. And I hope that you pay your quarterly tax payments so you don't have to come up with a big pile of money on April 15th. Most times, it's a company that will be challenged by the IRS regarding independent contractor status, like a firm, not the individual contractor. If a firm is treating their independent contractors the same way as they treat employees, by regulating their hours, ordering them in for mandatory meetings, interfering, say, with open houses, among other things, then the firm could be violating the rules that would have preserved independent contractor status for their agents. And what happens? The firm gets hit with tax penalties. According to the National Association of Realtors, as of 2021, of their 1.5 million members, 87% are classified as independent contractors. The NAR cites not only the common law test that we discussed, but the ABC test. Well, what is that? To be classified as an independent contractor, all of the following rules must be met. An individual is free from direction and control applicable both under the contract for the performance of service and in fact. The service is performed outside the usual course of business of the employer, and the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. The NAR points out that because of statutory supervisory and control requirement imposed on brokers over agents by a state, this could affect independent contractor status. The NAR also points out that real estate professionals have protection under IRS Code 26 USC 3508, which provides this framework for classification as independent contractors. This statute has been in effect since 1982. The federal government has, for tax purposes, recognized the unique nature of the real estate industry. It sounds as if there's a lot of challenges ahead for the real estate industry regarding independent contractor status for agents. It doesn't seem feasible to treat a firm's real estate licensees as employees, because that would probably change the long-standing real estate model. Apparently, in some states, real estate agents designated as independent contractors challenge their status as such. These challenges were attempts to reclassify the agents as employees, probably to obtain conventional benefits not offered to independent contractors. Well, that's it for part 2, and I'll see you in the next video.